Good morning and welcome to our last Knowledge Bank of 2021, Legal Lessons Learned. Today's webinar is hosted by Cassandra Zanelli, Solicitor and CEO of Property Management Legal Services. She will be debriefing on what has been a difficult year for some post-COVID and talking you through some of the legal lessons learned based on the decisions of the courts and the tribunals. If you have any questions throughout the session, please submit them via the Q&A button at the bottom of your screen, and Cass will try to get through as many as possible at the end. Today's session is being recorded and the recording will be available to watch later today. I will now pass you over to Cass. Good morning, Cass.
Good morning. Thank you very much for inviting. I'm good, thanks. How are you?
Good, thank you.
Ready for Christmas?
Nearly.
Do you want to come and do mine when you've got yours sorted? Yeah. It's just crept up on me. It's like it's a week and a bit to Christmas. Need to buy presents and get them wrapped. I love Christmas though. We should have done this in Christmas jumpers like we did last year.
I was thinking exactly the same thing today. We just missed it last week and I thought we should have scheduled that date because then it would have been like your annual Christmas jumper session. Never mind.
Next year.
Yes, 100%. Okay, I'll leave you to it and I'll jump back in at the end when you're finished.
Brilliant, thank you. Thank you and good morning everybody. Welcome to Legal Lessons Learned. What did we learn from 2021? Over the next hour, I will be running through some of what I think are the important legal lessons that we learned or should have learned from 2021 and leaving you with a lesson that I think we're going to learn, hopefully, in 2022. As Vicky says, if you have any questions, then by all means, put them through in the question box. They show up on my screen that you have asked a question, so I'll be able to pick those up either as we go or at the end. The first lesson that I think we should have learned, probably already know, but if we had a reminder about it in a couple of cases from 2021, is that it's really, really important to read, understand, and implement the terms of your leases. And it's particularly really, you can see that I'm saying this a lot, can't you? Really important to serve a contractually valid service charge demand. So that's lesson number one, the importance of serving a contractually valid service charge demand. And we know, don't we, you know this, that there are a bunch of contractual and statutory restrictions on the recovery of service charges. The contractual restrictions are lease specific, so they depend on what's in your leases, and they will vary from development to development because there's different sets of leases for one development compared to the development next door, development down the road in the next town, etc. So your contractual restrictions are lease specific. You then have a bunch of statutory restrictions, and those statutory restrictions apply in every case, so they apply across the board. And you need to make sure that you're demanding your service charges in accordance with both those contractual restrictions and those statutory restrictions, because bad things can happen if you don't demand your service charges in accordance with those contractual and statutory restrictions. And the bad thing that can happen is that these service charges aren't payable, and the effect of that can be suspensory. So if you get it wrong, you correct it, and when you correct it, these service charges become payable. But in certain circumstances, failure to comply with those restrictions is fatal to the recovery of those service charges. So they become stale, they become unrecoverable, and they can never be recovered. So it's really important to make sure that you are complying with those statutory and contractual restrictions on the recovery of service charges. Now, when you're dealing with contractual restrictions, and this is what our first lesson is all about, you're looking for a few things. You're looking firstly to make sure that your lease provides for the payment of a service charge. Hopefully it does. You're then looking to make sure that you're demanding in accordance with the terms of the lease. So are you calculating in accordance with the apportionment that's set out in the lease? Are you recovering costs via the service charge mechanism that you can actually recover as service charges? And that's that compare contrast exercise that I talk about, where you have your budget, you have your lease, and you make sure that what's on your budget is recoverable under the terms of your lease. And you also, when you're dealing with contractual restrictions, need to make sure that you're complying with any preconditions. If your lease sets out that certain things must be done before the liability on the part of the lessee to pay service charges have to be done, then you need to make sure that you do those things. Preconditions generally are about accounting related stuff. But the example that I always give, so forgive me if you've heard this example before because it's a daft one and I've yet to see it in a lease. But if your lease says your service charges must be demanded on pink paper with purple spots, then you need to make sure you're demanding your service charges on pink paper with purple spots. I've yet to see a lease that says that. If you do have one, then please share it with me. So those are the contractual restrictions. And we've learned from the courts, we've been reminded by the courts this year why it's so important to comply with those. I've mentioned the statutory restrictions, and some of the later lessons that we'll talk about deal with some of those, but just to deal with all of the restrictions of the one are at the start. Then your statutory restrictions are, firstly, does your service charge demand identify the landlord? So does it give landlord's name and address, together with an address for service including service of notices and proceedings in England and Wales, and that's sections 47 and 48 of the Landlord and Tenant Act 1987. Secondly, if the service charges relate to qualifying works or a qualifying long-term agreement, has the consultation process been followed or dispensation from consultation granted by the tribunal? And that's section 20 of the Landlord and Tenant Act 1985. Thirdly, are the service charges reasonably incurred? And if they're incurred in connection with the provision of services or the carrying out of works, are those works or services of a reasonable standard? And that's section 19 of the 85 Act. Fourthly, was the demand for service charges accompanied by the requisite summary of rights and obligations? And you'll know that there's a summary relating to service charges, and there's a separate summary in relation to administration charges if you're demanding admin charges. The requirement to serve the rights and obs for service charges is set down by section 21B of the 1985 Act. And within 18 months of the cost being incurred. And that is section 20B of the 1985 Act. So those are the statutory restrictions on the recovery of service charges. And as I say, we've had some reminders this year of the importance of serving a contractually valid demand, and we've had some reminders of the consequences if a contractually valid demand isn't served. I say we've had reminders because there's a line of authority in this, going back to a case you're probably all familiar with in the Upper Tribunal from 2011, and that's the Brent and Shulam B case. And it was the High Court in that case that told us that a demand for the purposes of section 20B(1) had to be a contractually valid demand. And that decision of the High Court was approved by the Court of Appeal back in 2017 in the DBS, or the Skelton and DBS King's Homes case. So we know that it's important to serve a contractually valid demand. And at the start of this year, we had a case in the Upper Tribunal called Stain and Richmond. It's H. Stain Limited versus Richmond. And in that case, the Upper Tribunal looked at the clauses in the lease and looked at whether those clauses in the lease had been complied with when the service charges had been demanded. And in Stain and Richmond, the lease contained a clause that required the lessee to be given not less than 1 month's notice of such advanced payment or contribution. So 1 month's notice of their service charge payment or contribution. The demand received by the lessee included the wording, payment due 30 days after the date of demand, arrears by return. And the question, therefore, in Stain and Richmond is whether the correct notice period had been given in the service charge demand, and therefore whether that demand was a valid demand. So that was the nub of what the upper tribunal were looking at in stay and enrichment. So the lease in stay and enrichment wasn't particularly complicated or complex. In fact, it was all a bit boring and conventional. And in the lease, the responsibility was placed on the landlord to repair the structure, for the maintenance of the common parts, etc. And under the terms of the leaseholder was required to pay a service charge in order to meet the landlord's expenses in carrying out those functions, providing those services. By one of the clauses of the lease, and it's clause 3.6, the lessee had covenanted to pay the landlord upon demand a rateable or due proportion of such sums as may be incurred or provided for by the landlord in accordance with their covenants, provided that if the lessee so requires, etc., I'm just reading from the clause, and that not less than 1 month's notice of such advance payment or contribution is given to the lessee. So the covenant obliged the lessee to pay service charge, provided that not less than 1 month's notice of such payment was given to the lessee. So that's the important bit here, that the machinery in the lease requires not less than 1 month's notice to be given to the leaseholder. And in terms of what happened, in July 2015, the landlord appointed a new managing agent to manage the block of flats. On the 18th of August, so 18th of August 2015, the new managing agent wrote to the lessee enclosing an invoice for service charges for the period March 15 to March 16. And the invoice said that there were charges of just under £2,500 outstanding. Now, at the bottom of that invoice, the landlord's name and address were given, so tick section 47, along with details of the agent's bank account. And this statement that I'm about to read out to you also appeared in capital letters at the bottom of the demand. And the statement in big capital letters said, payment due 30 days after date of demand, arrears by return. That service charge wasn't paid. Leaseholder didn't pay it. It happens sometimes, doesn't it, where leaseholders don't pay the service charges? Happened here. Leaseholder didn't pay, and in May of the following year, so May 2016, landlord brought proceedings against the lessee in the county court for non-payment of service charges. The lessee defended those proceedings, and the matter was subsequently transferred to the tribunal. The FTT looked at the demand, it looked at the lease, and the FTT decided that the service charges hadn't been demanded correctly because it allowed 30 days rather than a month, and therefore that those service charges weren't payable because that contractual machinery in the lease hadn't been followed, so says the FTT. Landlord wasn't happy with that, perhaps understandably, and therefore appealed that decision to the upper tribunal. And you'll know that the appeal process works so that a decision in the FTT is appealed to the upper tribunal. And there were two issues for the upper tribunal to consider here. The first was, what actually does the lease require in terms of the form of a service charge demand? What does that clause mean? And secondly, did that invoice on the 18th of August 2015 satisfy those requirements? So what does the lease actually want? And does the invoice that was sent, does the service charge demand that was sent tick those boxes in terms of what the lease wants? Does it satisfy those requirements? Unfortunately for the landlord, the upper tribunal agreed with the FTT, and the upper tribunal agreed that the service charge demand didn't comply with the minimum requirements set down by clause 3.6 of the lease. So the demand wasn't in compliance with the lease. The upper tribunal said that the lessee was entitled to receive not less than 1 month's notice of the sum demanded in advance before that liability to pay takes effect. And the upper tribunal said this, and I'll quote from what the upper tribunal said. They said, the giving of notices is a condition of liability, and it requires a particular step to be taken by the landlord to inform the tenant not only of the amount which must be paid, but of the date by which it must be paid. That date must be not less than 1 month from the giving of the notice. If that condition is not satisfied, the sum is not payable. And we know from Section 61 of the Law of Property Act 1925 that the requirement to give 1 month's notice means a calendar month. So the demand for payment in 30 days arrived on the 19th of August and expired on the 18th of September. So accordingly, it didn't provide for the requisite 1 month's notice. The lease says 1 month's notice, the demand didn't match up with what the lease said. So the landlord, in that case, in Stain and Richmond, hadn't followed that really clear contractual machinery. Because they hadn't followed that contractual machinery, they hadn't served a contractually valid service charge demand, and because they hadn't served a contractually valid service charge demand, those service charges weren't payable. So that case really hammers home a reminder, doesn't it, of the importance of reading, understanding, and implementing the terms of your leases and following that contractual machinery that's set down. It was a really, really simple mistake to make, but the machinery set down by the lease was clear that it needs to be 1 month's notice, and that's not what was given. And in order for that service charge to be payable, the lease has to be followed, and that 1 month's notice has to be given. So guys, if you're not reading, understanding, and implementing the terms of your leases, a reminder from the upper tribunal in Stain and Richmond of the importance of that. Our second lesson, we've got no questions that have come in yet. Our second lesson that we hopefully learnt in 2021 follows on from what I've been talking about there. And it's a case that not only reminds us again of the importance of contractually valid demands, but also reminds us of the importance of Section 20B2 and Section 20B2 notices. And it's the West India Key Residential Limited and East Tower Apartments Limited case. And that's a decision that came out from the Court of Appeal in the summer. Many of you will probably be familiar with that case. And it's based on, again, the raft of contractual restrictions that exist in relation to the recovery of service charges that are, like I say, lease specific, and also the raft of statutory restrictions that exist in relation to the recovery of service charges. And we know, mentioned a few of them, we know that the courts and tribunals are littered with cautionary tales, and they're littered with cautionary tales where landlords, and when I say landlords for these purposes, I mean those that are entitled to enforce payment of a service charge, because that's how landlords are defined under Section 30 of the 1985 Act. So the courts and tribunals are littered with cautionary tales where landlords have failed to comply with those contractual and statutory restrictions. Now, in some instances, those that non-compliance can be corrected because the effects of it are suspensory. For example, if you send a service charge demand without the rights and obligations, you can resend that demand with the rights and obligations accompanying it, and at the point you resend it with the rights and obs, it becomes payable. But there are certain circumstances, and we'll read about those, hear about those in West India Key, where instances of non-compliance are fatal to the recovery of service charges. And Section 20B, the so-called 18-month rule, is one of those instances where non-compliance is fatal to recovery. If you don't demand your service charges within 18 months of those costs being incurred and serve a contractually valid demand, those service charges become stale. unless you have served a valid Section 20B2 notice. Stale service charges are unrecoverable. You will have or will be an unhappy landlord if you have a tranche of service charges that aren't recoverable because you've fallen foul of Section 20B. So if you don't comply with Section 20B and don't correct it quick enough, those service charges become stale. Stale service charges are unrecoverable. That's why, and there is that overlap between contract and statute in terms of the restrictions here, because you have to make sure you're serving a contractually valid demand. There's that overlap between the two of them. And it's why it's so important to make sure that you're not only complying with what statute requires in terms of the restrictions, but also complying with what the leases require in terms of the restrictions, because leases are contracts at the end of the day. So 20B and issues relating to 20B were back before the Court of Appeal in its decision that was handed down in July in number 1 West India Quay Residential and East Tower Apartments Limited. I've touched on Section 20B, but let's dive into that a little deeper. So Section 20B is a statutory time limit on making demands for service charges. That's in essence what it is. So it operates so as to impose a strict time limit of 18 months, and that 18-month clock starts ticking from the date on which costs are incurred. That's when your 18-month clock starts to run, when you incur costs, because Section 20B says that you have 18 months from incurring those costs to demand them as a service charge. And if more than 18 months have elapsed before a demand for a contractually valid demand for service charges is served, and the leaseholder isn't going to be liable to pay those costs. They're stale, they're unrecoverable. There is an exception to that, and the exception to that is under Section 20B2, and that enables any landlord, to say for these purposes, is the person who's entitled to enforce payment of service charge. So Section 20B2 enables any landlord to serve a Section 20B2 notice. And that Section 20B2 notice puts the lessee on notice that costs have been incurred and that the lessee will subsequently be required under the terms of the lease to contribute to those costs by means of payment of a service charge. That Section 20B2 notice has to be given within that same 18-month period, so within 18 months of the cost being incurred. What that means is that in order not to fall foul of the 18-month rule, a landlord either has to firstly serve a contractually valid demand for service charges within 18 months of those costs being incurred, or serve a valid Section 20B2 notice. A landlord must do one of those two things within 18 months of the cost being incurred. If a landlord doesn't do that, service charges become stale, they become unrecoverable. I suppose the reason behind why we have this statutory time limit on making demands is to get around the problems that might be faced by lessees of finding themselves faced with unexpected bills, if that wasn't the case. So back to, now that we've deep dived, that's a word, into Section 20B, back to West India Quay and what West India Quay had to say. West India Quay is a technical legal phrase stonking development in London. It's a hotel, there are flats, there's service departments. It's a massive development, massive mixed use development, like I say, hotel with residential flats atop. The lessee here, so East Tower Apartments Limited, held around 30 of those flats, so held the leases to around 30 of those flats. There has been litigation ongoing between these two parties for years, so I will try and simplify it as much as possible to make the points that we need to talk about with our lesson for this one. But under the terms of the leases, under terms of those flat leases, the landlord was entitled to recover the cost of providing electricity. And it was also entitled as a separate covenant to recover costs incurred in providing services to the building as a service charge. So 2 routes to recovery, if you like, there for the landlord. One, to recover costs of providing electricity. The second, to recover by the service charge mechanism costs incurred in providing services to the building. This building has a hideously complex utility metering system. And in order to try and navigate their way through this complex metering system, the landlord retained specialist contractors to read the meters and assist in the allocation of costs between the commercial and the residential parts, and ultimately to produce individual bills to then be recharged to each of the leaseholders. And between 2008 and 2012, landlords charged those costs of those contractors as a surcharge on the electricity costs. So it didn't add these as service charge costs, but added to them to the electricity costs that it was demanding out to the lessees. As I say, there is a long line of pretty complex litigation here. And in litigation that goes back to 2015, the FTT said that what the landlord was doing was okay, that was right, that was the right practice. The upper tribunal a year later disagreed. What the leaseholder in this one said is that, well, because of that upper tribunal decision, those earlier demands where you try to recover these costs under the electricity clause rather than the service charge clause are invalid, because you've tried to recover these costs as a surcharge on the electricity and not via the service charge mechanism. So the leaseholder says there's been no contractually valid demand served for the purposes of Section 20B1, and more than 18 months has passed since those costs have been incurred, and you've not served a Section 20B2 notice. Therefore, says the leaseholder, you can't recover any of those costs. FTT agreed with the leaseholder, as did the upper tribunal, and therefore this found its way to the Court of Appeal, and the Court of Appeal dismissed the landlord's appeal. What the Court of Appeal said was that the purpose of Section 20B is to ensure that within 18 months of costs being incurred, that a leaseholder knows the full extent of their contractual liabilities. A contractually invalid demand by a landlord did not, say the Court of Appeal, give rise to a contractual liability to pay on the part of a lessee. In order to comply with Section 20B1, a landlord was required to make a contractually valid demand within 18 months of incurring the costs. And the Court of Appeal recognised that this could lead to some harsh results in individual cases, but that's the nature of a limitation period, says the Court of Appeal. And it's inherent in limitation periods that there's sometimes going to be harsh individual results. So the Court of Appeal here had, I use their words, little hesitation in concluding that a demand for the purposes of Section 20B1 must be a contractually valid demand and served in accordance with the service charge provisions of the lease. So that's another reminder, in case you needed one, of the importance of reading, understanding and implementing the terms of your leases and following that contractual machinery. But it's also, I think more interestingly perhaps, a reminder of the importance of serving, or the usefulness of serving, a Section 20B2 notice. Because remember, I said that you stop the 18-month clock ticking if you serve a valid demand, contractually valid demand, within 18 months of incurring the costs, or you serve a Section 20B2 notice. And I wonder how many of you watching this that are managing properties or involved in the management of them, whether you are, as a matter of course, serving Section 20B2 notices. So I think they're useful, and particularly useful if you're service charge machinery in your lease works that leaseholders pay a fair and reasonable proportion of the service charge costs. Because we'll find out in a minute in the next case we look at that could be changed by the tribunal. So if you are demanding service charges based on fair and reasonable proportions, it may well be worth your while, for reasons that we'll discover in a minute, serving and maybe including within your year-end accounts a Section 20B2 notice in order to protect your position should you need to go back at a later stage and twiddle with those apportionments. There's no prescribed form of Section 20B2 notice. The 1985 Act lays out the specific requirements as to the information that the Section 20B2 notice should contain, and those requirements have been interpreted quite strictly by the courts. But as I say, what I think is the lesson, not just to make sure you're serving a contractually valid demand, but also to maybe adapt your practices so that Section 20B2 notices aren't done occasionally, but become more frequent, and perhaps the default position that you are serving your Section 20B2 notices now. Something to think about, particularly where lots of you are coming to year end. Year end is a lot of the time, isn't it? It's 31st December. You'll be getting your year end accounts together in the new year. Maybe think about, as part of that and as part of your accountancy practice, to add that Section 20B2 notification to your accounts. Which is a nice segue then into the next case to talk about. And this is all to do with fair and reasonable apportionment. And when your leases require service charges to be paid based on a fair and reasonable proportion. And the lesson really from this one is that what's a fair and reasonable apportionment is within the gift of the tribunal. Most well-drafted leases are going to set out how service charges are apportioned between lessees in a block. Some leases will give fixed apportionments, so 2.5% or whatever it may be. Other leases require lessees to pay a fair and reasonable proportion. You also have a hybrid option sometimes as well, where you have leases that set out a fixed apportionment, but then appear to give the landlord or some other third party the ability to vary, let's say twiddle again, the ability to vary that apportionment. And there have been a number of cases over the recent years all about Section 27A, subsection 6 of the Landlord and Tenant Act 1985, and the extent to which Section 27A6 invalidates those service charge provisions. Started off with the Windermere Marina case back in 2015, 17, something like that. And then we went on through Gator and Wellington, and we've now got the Aviva case. And that's the one that we're going to talk about. Section 27A of the Landlord and Tenant Act 1985 is the section that sets out the jurisdiction of the tribunal. In England, FTT; in Wales, LVT. And it says, Section 27A1, it says that an application may be made to the tribunal for a determination whether a service charge is payable, and if so, as to the person by whom it's payable, the person to whom it's payable, the amount which is payable, the date at or by which it's payable, and lastly, the manner in which it's payable. So those are the 5 elements of the tribunal's jurisdiction when it's determining service charges: by whom, to whom, how much, the amount, the date at or by which it's payable, and the manner in which it's payable. Those are the 5 things the tribunal will determine when they're dealing with service charge applications made under Section 27A. Section 27A4 says that no application can be made if it's in respect of service charges that have been agreed or admitted, or have been the subject of determination by the court, or have been referred to arbitration pursuant to a post-dispute arbitration agreement to which the tenant is a party. Section 27A6 goes on to say, an agreement by the lessee of a dwelling other than a post-dispute arbitration agreement is void insofar as it purports to provide for a determination in a particular manner or on particular evidence of any question which may be the subject of an application under subsections 1 and 3. This is why we've had quite a few cases on section 27A6. So the question for the Court of Appeal in the Aviva Ground Rent and Williams case, which is the one that we're talking about, was whether the landlord was restricted to the specified percentages set out in the lease, or whether there was an ability to specify different percentage, and if so, whether the landlord could specify that, or whether that ability to specify that different percentage was transferred from the landlord to the tribunal. So we have in Aviva and Williams a mixed-use development in Southsea. I used to live in Southsea. Southsea is nice. So mixed-use development down in Southsea, and the service charge clauses within the occupational leases had 3 components. So essentially you have 3 schedules: insurance, building, estate costs. And the leases said something like this: your share of insurance costs is 0.7%, or such other part as your landlord may otherwise reasonably determine. Your share of building services costs is 0.71%, or such other part as your landlord may otherwise reasonably determine. Your share of estate services costs is 0.54%, or such other part as your landlord may otherwise reasonably determine. Now, the upper tribunal, when it got hold of this, grappled with section 27A6 and grappled with the previous decisions in Windermere Marina that I've mentioned and Gator that I've also mentioned. And in Windermere Marina, the leases obliged each lessee to pay a fair proportion to be determined by the surveyor of the lessor, whose decision shall be final and binding, of the expenses for communal services. In Gator, the leases required each lessee to pay a due and fair proportion of the service cost, such proportion to be determined by the landlord or its surveyor, in each case acting reasonably. In both of those cases, so in both Windermere Marina and in Gator, the upper tribunal held that the effect of section 27A6 was to delete the words "to be determined by the surveyor," or similar, whatever it said, which then left the tribunal to decide what a fair proportion of the service charge was. That's the impact of section 27A6. As the tribunal put it in Windermere Marina, section 27A6 deprives the landlord surveyor of his role in determining the apportionment. The lease is to be read as if the method of ascertaining a fair apportion was omitted altogether. And therefore, when this case worked its way up through the upper tribunal and up to the Court of Appeal, the Court of Appeal said that there was a clear thread that runs through the previous decisions of the upper tribunal. And what the Court of Appeal said is that section 27A6 is concerned with no more than removing the landlord's role, or that of a third party, from the decision-making process, in order not to deprive the FTT of their jurisdiction under section 27A1. And 27A1 is the ability the tribunal has to determine if a service charge is payable, and if so, by whom, to whom, the amount, manner, the date or by which it's payable. What the Court of Appeal then went on to say is that that statutory objective is satisfied if the landlord's role in determining what a fair and reasonable proportion is transferred from the landlord to the tribunal. In this case, the service charge provision envisaged that the lessee may be liable to pay as an alternative to the fixed percentage a different percentage that is identified by somebody acting reasonably, and that someone is the landlord. The Court of Appeal say it's only the second component of that that's invalidated by Section 27A6. And they say that the lease should be read as if it had provided for a fixed percentage or such other part as may otherwise reasonably determine. So what you have as a result of all of that is that you have a vacuum. You have a vacuum where there's a fixed percentage, but the ability to vary that, and the vacuum is the person who has that ability to vary and to amend that fixed percentage. And the Court of Appeal, we know from the Court of Appeal in the Aviva and Williams case that that vacuum is filled by the tribunal. So the function in making that determination as to what the fair and reasonable proportion is, what the fair and reasonable percentage is transferred because of the operation of Section 27A6. It's transferred from the landlord to the tribunal. Now it is open to either the landlord or the lessee to refer the question of a different reasonable percentage to the tribunal if the parties can't agree it between them. But it's the tribunal who will fill that vacuum. It's the tribunal, parties can't agree, who will say what that fair and reasonable apportionment is. The tribunal who will say what percentage the leaseholders will pay towards that overall schedule of expenditure. And that follows what we were talking about at the end of the last lesson, where we were saying about the importance of Section 20B2 notices. If you have a lease that's based on service charge apportionments on a fair and reasonable apportion, or if you have a lease that's got a fixed percentage and the ability to twiddle that fixed percentage and you're doing so, then Section 20B2 notices really are, I think, quite important, just in case you as a landlord face any challenges from lessees who seek to challenge the decisions you've made in relation to apportionment, bearing in mind that there is that vacuum there, and it's the FTT who are going to fill that vacuum with what they think is a fair and reasonable apportionment. I'll move on from service charges and talk about the last case to talk about is a company law case. And the lesson from this one is that a request under Section 116 of the Companies Act 2006 must be valid at the time that it's made, and the validity of that request can't be corrected later. By way of reminder then, guys, it is a requirement under Section 113 of the Companies Act 2006 for every company to keep a register of its members. There are no exceptions because these companies are RMCs or RTM companies. There's nothing in the Companies Act that says every company, bar an RMC or bar an RTM company, must keep a register of its members. Every company is under an obligation to keep a register of its members. And that register of members has to set out certain things, has to contain certain information, including the name of the member or members, their address, the date on which they became a member, and the date on which they ceased to be a member. If it's a company limited by share capital, so where you have shareholders, then it has to set out the number and class of shares held as well. Not only does your register have to contain your existing members, but it also has to detail any ceased members as well, so where they ceased to be a member in the last 10 years. So you have quite a bulky register by the time that you've done of existing members and ceased members. And it's worth remembering that failing to keep a register, so failing to comply with Section 113, is a criminal offence. Companies Act is littered with criminal offences. Under Section 116 of the Companies Act, any member of a company may inspect or obtain a copy of a company's register of members if they make a request. Section 116 request. Now, there is no prescribed form of Section 116 request, so there's nothing that you can go to the internet and download and this is the form, this is your prescribed form for making a Section 116 request. But Section 116, subsection 4, does set out the requirements of what a valid Section 116 request looks like. And Section 116.4 makes clear that the request must, this is a must contain the following information. In the case of an individual, it must contain that individual's name and address. In the case of an organisation, so if it's an organisation making the Section 116 request, it must contain the name and address of an individual responsible for making the request on behalf of the organisation. The Section 116 request must set out the purpose for which the information is to be used, and also whether the information will be disclosed to any other person. If it will be disclosed to any other person, then it has to set out, if it's an individual, the name and address of that person. If it's a company or an organisation, sorry, the name and address of an individual within that organisation responsible for receiving the information and the purpose for which that other person is going to use it. There is an earlier decision of the High Court that makes clear that a valid request to inspect the register members must contain all of that information set out in Section 116.4. I don't know if any of you have received Section 116 requests. I'm finding that they're becoming more and more common, and finding that company law challenges generally are becoming more and more common. It's not just challenges relating to matters of leasehold management. You're also seeing, or I'm noticing anyway in my practice, an increase in corporate-based challenges these days. If you are a company on the receiving end of a Section 116 request, then you have 5 working days to do something with that request. 5 working days isn't a long period of time. So please don't put this in the too difficult to deal with pile. And I know that we all have a too difficult to deal with pile. I'd fully take that on board. But if you do get one of these, don't put it in that pile, do something with it. 5 working days to do something. And that something that you do with it is either to allow inspection or to provide a copy, if it's a valid Section 116 request that's been made, or if you think it's invalid or not for a proper purpose, then you refer that request to the court. And essentially, you're asking the court to make a no access order. If the court is satisfied that inspection or a copy of it isn't being sought for a proper purpose, the court will direct the company not to comply with Section 116 request and will make a no access order. And you're likely, as well as part of those same proceedings, to get an order for costs in your favour if you've been successful in getting your no access order. Unless you apply to the court and get your no access order, then a company must comply with that request for access. Non-compliance with that request for access under Section 116 is a criminal offence. It incurs a criminal penalty. I say again, Companies Act is littered with criminal offences. So we've talked about 2 sections, both of them come with the commission of a criminal offence if you don't comply. So what's really important is that if you get that Section 116 request, that you do something about it and do something about it quickly, 5 working days, either to hand it over or allow inspection of the register, or to make that application to court for a no access order. It's a criminal offence if you don't hand the register over, and you should have done. But what happens, now that I've jumped off my soapbox, what happens where an invalid request is made? And the question for the court in this case was, can an invalid request be corrected by either by supplying the missing information at a later date? And this was the Sir Henry Royce Memorial Foundation versus Hardy case that was dealt with in the High Court back at the beginning of this year, so it's a little while ago now. The company in question was a company limited by guarantee, as many RMCs are, and indeed as all RTM companies are, and it was also a registered charity. The company was run by a board of directors, and the board of directors was elected by its members. Striking a bit of a chord here, isn't it, with the day-to-day stuff that we deal with. In November 2019, Mr. Hardy became a member of the company, and shortly thereafter, so a month later in December 2019, he became finance director of the club. On the 10th of February 2020, Mr. Hardy wrote to the company indicating that he wished to exercise the rights given to members under Section 116 of the Companies Act 2006 to inspect and take a copy of the register of members of the company. Now, the letter that Mr. Hardy sent on the 10th of February 2020 gave his name and address, tick, and it detailed the purpose of the request, tick. However, always a but, isn't there? But the letter on the 10th of February from Mr. Hardy didn't state whether the information would be disclosed to any other person, and if so, the name and address of that person and the purpose for which they were going to use the information. So you remember a couple of minutes ago, I set out, didn't I, the requirements of Section 116, name and address, purpose. Are you going to disclose it to anybody else? And if so, who and why? Mr. Hardy's letter gave his name and address, gave the purpose, but didn't set out whether the information would be disclosed to any other person. On the 13th of February, so 3 days later, and the company wrote to Mr. Hardy, refusing him access to the register and telling Mr. Hardy that they were going to apply to the court under Section 117 for a no access order. Mr. Hardy replied quite quickly to that letter, 15 minutes after, in fact, saying, I have just noticed, says Mr. Hardy, that I have inadvertently omitted from my request the statement that I would not be making the information available to any other person. I confirm this was an oversight on my part and that I have no intention of making the information available to any other person. 18th of February, the company issue a claim under Section 116 of the Companies Act. And the High Court, because these kind of things are dealt with by the High Court, held that the company had succeeded in its claim, and the High Court made a no access order. This is the interesting bit, though. High Court say that the phrase, I have no intention of making the information available to any other person, which is what Mr. Hardy said in his email on the 13th of February, is sufficient to comply with Section 116. It's enough. Statute doesn't require the requesting party to make a promise. They're not needed to pinky promise. What the statute requires them is simply to make a statement which is going to assist the company in deciding how to react to the request, and in particular whether to apply to the court for a no access order. However, say the High Court, a request under Section 116 has to contain the information specified in Section 116(4). The request that was made on the 10th of February was not a valid request, say the High Court, because it didn't contain all of that information. High Court went on to say, you can't correct that. That invalid notice could not be corrected and made whole by the additional information that was provided by Mr. Hardy in his email 3 days later on the 13th of February. The company, when it receives the Section 116 request, say the High Court, need to know where it stands. A company's got 5 working days to do something. That's not a very long period of time. And they need to know where they stand there and then when that request is received, because there's not a lot of time to do anything with it. And there are criminal sanctions if a company and its officers get this wrong. Court recognised that and say that there's only 5 days to issue proceedings if an invalid request is made, the company wishes to challenge it, and so say the High Court. The request is either valid or it's not at the time that it's made. Its status doesn't change depending on what happens later. So Mr. Hardy hadn't made a valid request on the 10th of February because he hadn't set out all of the information that was required by Section 116. It didn't matter that he tried to correct that later. It couldn't be corrected. What mattered was when that request was received on the 16th, is it valid? Yes or no? It's a black or white thing. It's not something that can be corrected by information that's received later down the line. And so therefore the no access order was granted and stood because the Section 116 request wasn't a valid request. We have 3 minutes, and in the last 3 minutes of this webinar, looking back at what we've learned, and there's lots more that we could have learned in 2021, but we've only got an hour to talk to you all day about it. Looking back over 2021, I thought that we'd spend the last couple of minutes looking forward to what 2022 might bring. Bit of crystal ball gazing, living up to my namesake, Cassandra being the prophesizer, although I think she was prophesizer of doom and gloom. Hopefully this won't be doom and gloom. There was a case heard by the Supreme Court last month, and it's the first time that an RTM case has wound its way up to the Supreme Court. And that was the case involving First Port and Settlers Court RTM company. And the case deals with the problem, and I know it's a problem, of dual management. And this is something that happens where an RTM company acquires the right to manage their particular block, but you have a multi-block estate, multi-tenure estate, where there are shared services. It might be something really simple like a bin store or a car park, or it might be something far more fancy and complex like gyms or leisure facilities, whatever it might be. And there's a problem at the moment as to who manages those shared services, who manages the pertinent property, who manages the estate, and how those costs are recovered, whether they can be recovered. So that is and was before the Supreme Court back on the 10th and 11th of November. I acted in those matters because I acted on behalf of Armour, who intervened in that appeal, and hopefully we will have a decision, I say in New Year, maybe I'm being optimistic, maybe it'll be a little bit later than that, but we will certainly have a decision in 2022, put it that way. We'll have a decision in 2022 as to what happens in those circumstances where you have that tension, and I don't say because the parties are tense with each other, but the tension that's created where you have a block that adopts and goes down the right to manage route, who manages that pertinent property, who manages those shared services, will hopefully have an answer to that problem of dual management on a multi-block estate. So watch out for that one coming in 2022. That's going to be an important decision for us all. Let's have a look in, oh, I was about to say let's have a look at some of the questions, but the clock has just ticked over to 11 o'clock. Sorry.
Hi.
Hi, Vicky.
Hi. Yeah, I was going to say we've got a few questions, but I can send them over to you, and then if you want to follow up individually, then that's absolutely fine.
Brilliant, thank you.
Yeah, I think that was the perfect session actually to end our knowledge banks for the year. Went really, really well.
Thank you. Hopefully everybody found it useful.
Yeah, definitely. I think it was really informative.
Thank you.
Okay, well, thank you so much, Cass, for joining us again. You've done some great sessions this year for us. Thank you everyone else for joining us, from myself and the News on the Block team. I hope you all have a lovely Christmas, and hopefully we look forward to seeing you all in the new year, hopefully at some more live events and some more online events.
Brilliant. Thank you. And
Thank
thanks
you
again
so
for
much.
having me. Merry Christmas.
Have a lovely Christmas, Cass. Bye.
Bye.